2, requiring the breaching party to the non-breaching party. According to the Commercial Law 2005, a penalty can only be applied if it is specifically agreed upon in the contract. If the contract does not stipulate it, no penalty can be claimed. In international sale contracts, penalty clauses are commonly used to enforce responsibilities and enhance the parties' compliance with the contract. Common cases include penalties for late delivery, penalties for non-conforming goods in terms of quality, quantity, or specifications, and penalties for late payment. For example, a contract may stipulate in case of delayed shipment, the seller has to pay to the buyer the penalty charge at 0.25% of the value of the delayed goods. This means that in the event of late delivery, the seller must pay the buyer penalty equal to 0.25% of the value of the delayed goods. This provision helps compensate the buyer for part of the loss and pressures the seller to deliver on time. When drafting penalty clauses, it is necessary to clearly specify the cases in which the penalty applies, how the penalty is determined, and the basis for calculating the penalty, either based on the value of goods, the duration of the breach. To ensure transparency, feasibility, and minimize dispute during contract performance, the force majeure clause in international sales contracts is designed to suspend or exempt a party from performing contractual obligations when events occur that are beyond the party's control. A force majeure event refers to an occurrence that is beyond the will of the parties or has been pre-agreed in the contract and could not have been foreseen at the time of signing. When such an event occurs, even if the affected party has taken all necessary and reasonable measures to mitigate the consequences, it is still impossible to perform the contractual obligations. Moreover, the event must arise after the contract is seen and directly prevent the performance of the contract. If the breaching party can fully demonstrate that the conditions of force majeure are met, they will be exempt from legal liability arising from the breach, such as penalties or compensation for damages. To minimize disputes, a force majeure clause in the contract should be clearly and fully drafted. It should include a list of events considered as force majeure, such as natural disasters, wars, epidemics, embargoes, or changes in government policy. Procedures for acknowledging and notifying the occurrence of a force majeure event, and methods for handling its consequences, such as extending the performance period, suspending obligations, or terminating the contract if the event persists. In international sales contract, a claim is when one party requests the other to resolve losses, damages, or breaches of contract caused during the performance of the contract. Claims serve to protect the legal rights of the aggrieved party and act as a preliminary step before taking disputes to arbitration or court. The contract should clearly specify the form of the claim. Typically, claims must be made in writing stating the content of the complaint, legal grounds, the amount of compensation requested, and accompany the supporting documents such as inspection reports, quality certificates, bills of lading, and invoices. The contract should also define the time limit for making claims, usually counted from the moment of receiving the goods, discovering a breach, or receiving relevant documents. If a claim is not made within this period, the aggrieved party may lose the right to claim. Additionally, the contract should clarify the rights and obligations of the parties during the claims process, such as the obligation to cooperate, provide evidence, resolve the claim within a reasonable time, and the right to request compensation or remedial actions. This ensures disputes are resolved transparently and efficiently and helps prevent prolonged conflicts. An arbitration clause is a provision in a contract whereby the parties agree to submit any disputes arising from the contract to arbitration instead of going to court. Once this clause is included, disputes will be resolved under the commercial arbitration mechanism, and the arbitral award will be final and binding on the parties. When drafting an arbitration clause, the most important requirement is that it should be concise, clear, and precise, especially specifying the name of the arbitration institution with jurisdiction to resolve the dispute, such as BIAC, SRC, or ICC. failing to clearly specify or incorrectly naming the arbitration institution may render the clause invalid or difficult to enforce when a dispute arises. In addition to the basic content, the parties may agree on other arbitration-related matters, such as the applicable procedural rules, the number of arbitrators, the place of arbitration, the governing law of the contract, the language of proceedings, and the allocation of arbitration costs. If the contract does not include specific agreements on these matters, dispute resolution will follow the procedural rules of the chosen arbitration institution. Applicable clause is a provision that determines which legal system will regulate the contract and resolve any issues not expressly covered or ambiguously addressed in the contract, such as validity, interpretation, and the duties and obligations of the parties. In international sales contracts, the parties have the freedom to choose the governing law. The law selected can be that of the seller's country, the buyer's country, a third country, or an international treaty mutually accepted by the parties. Clearly specifying the governing law increases legal certainty, reduces disputes, and facilitates dispute resolution in the future. A common way to draft this clause is to explicitly state that the contract is governed by a specific legal system. For example, the contract may stipulate that all matters related to the permission, validity, interpretation, and performance of the contract will be governed by the Vietnamese commercial law. In this case, if any issues arise that are not addressed in the contract, the dispute resolution authority will refer directly to the chosen law. Additionally, the parties may explicitly exclude the application of certain international conventions, such as the 1980 Vienna Convention on Contracts for the International Sale of Goods (CISG). In such cases, the contract will specify that it is not governed by CISG, even if the parties are from countries that are members of the convention. This approach is often used when the parties prefer to apply familiar national laws rather than a uniform international law. The warranty clause in an international sales contract is the seller's commitment to guarantee the quality of goods for a specified period, called the warranty period. During this period, if defects arise due to the seller's fault or during production, the seller must fulfill the warranty obligations as agreed. When drafting the warranty clause, the contract should clearly specify the warranty period, which may be counted from the date of manufacture, the date of delivery, the date of completed installation, or the date the goods are put into use, depending on the nature of the goods and the agreement between the parties. Regarding the seller's responsibilities, the seller must remedy any defects occurring within the warranty period if they are at fault. Remedies might include repairing or replacing defective goods or components, or reimbursing reasonable costs related to repair or replacement. Additionally, the seller must provide sufficient instructions for the use, installation, and maintenance of the goods. Regarding the buyer's applications, the buyer must operate and use the goods according to the seller's instructions. If defects are discovered during the warranty period, the buyer must preserve the goods in their current condition, promptly notify the seller, and invite relevant parties to verify the goods condition as a basis for claiming warranty. Proper compliance with these obligations ensures the buyer's warranty rights and helps prevent disputes.